Order in the court. Let's hear his try. Let's hear what the super lawyer has to say, guys. Let's hear what the super lawyer has to say. And I'm telling you, do I know Luca Tim? I don't know. I don't know nobody. I don't know nobody. All right, let's get to it. So this was filed basically a little after there's 123 1051. Now this is the super lawyer. This is the guy who is like, look, man, do not come at my client with this weak common law marriage on this circumstantial bullcrap evidence. Why are you wasting my time? Why are you wasting my client's time? You know he was never married. You know he never held out. You know he never said he was going to marry you, Sammy. Why are you doing this to my client? She's like, well, I just want the money. I don't want the McLaren. I want that steak deal. He's like, oh, you want the steak deal? Oh, okay. Well, it's not happening. It's not on my watch, God. I'm the super lawyer. This is my super lawyer, fucking Omni man out here. All right, let's get into what he has to say, man. Without further ado, let's get into it. And we gonna go slow, and we gonna get into it because this is a dub right here. This is game over. And since y'all juicers, y'all know all about this. Y'all know all about this. So now comes Mr. Cow, responded and files his bench brief regarding the informal marriage, and would show as follows. Now, look, this is what he quotes. Legal authority to prove the existence of an informal marriage in Texas, the proponent must show the parties, 1, agreed to be married. So he's just listing it. 2, live together in Texas. Look, you see that in Texas? Remember, guys, when I showed you, I forgot that motion. I forget the name of it. In Texas matters. In Texas, not in Canada, not in California, in Texas. You know, or all my exes are in Texas as husband and wife, and held them out to others in Texas as husband and wife. Okay, all 3 of these elements must exist at the same time for there to be a valid marriage. Okay, and he cites this Gary V. Now, look, this ain't something I wrote down because this is common knowledge. All right, at this point, I didn't cover a lot of this. This is common knowledge. He didn't cite just one case. He cited 2, Burden v. Burden. He cited 3, Nicholas Light. He like, look, all this have to occur at the same time in Texas, not California, not Canada when you're trying to get in the country to get them. Not there, in Texas. All right, guys. Pursuant to Family Texas Code, the court may render an appropriate order, including temporary injunctions for the preservation of property and protection of the parties, while the suit for dissolution of marriage is pending, and on the motion of the party or the court's own motion for notice of hearing. So he like, look, yeah, y'all got temporary orders. Put them in. I'm super lawyer. I knew this. I didn't need a 5-page paragraph, a paper to say you got temporary orders to put in, temporary order. I didn't need a 5-page brief to say you got jurisdiction to do temporary orders. I'm the super lawyer, guys. What are we doing here? Texas courts should follow sections 2.401 and 6.502 of the Texas Family Code and permit the parties contesting the existence of an informal marriage to put on evidence proving the absence of 1 or more or 3 elements of the informal marriage. So now the lawyer like, yes, put on your temporary orders. Fine. Put them on. But we can submit evidence that, hey, we were never married. How many hours of streams does Mr. Cow have where he say, hey, look, bro, I ain't ever getting married. I ain't thinking about marriage. If I do get married, it's going to be with a prenup. How many hours does he have saying that? Could you imagine in court, the judge, the jury, someone said 100,000 hours, literally watching Mr. Cow. Guys, I never going to get married. So Sammy can just get out of my life and I'll give her half the McLaren and we'll call it a day. And she's like, nope, I want the steak deal. And I was like, file for divorce. Sorry, look, no shade to Mr. Cow, but he talked fast. I can't talk that fast. I can talk fast for a second. I can talk fast for a second. All right, so now we know he has evidence. However, some courts follow the outdated prima facie standard. Look at this. Like, yo, bro, what you following this outdated laws? Come on, man. What you look, that's a professional shot, if you guys don't know. That's a professional shot. You could say at the court, or you could just say at Texas. But shout out to, I want to get these. Shout out to ain't no way after this trial she will be adept. I love how people are trying to get past my chat blocker. Yes, right. Adept is blocked, guys. You can't say it. Be creative. So, however, some courts follow the outdated prima facie standard set out in Ex parte 3, Texas 1960, and Ex parte 3. Look, he knew it was coming. This is chess, not checkers. He knew the moves. He's like, oh, they like Mr. Kyle. Just relax, man. Just relax. I know what they're going to do. They're going to come at you with this old law to try to jam you up. And, man, I seen it coming a mile away. This came to me in undergrad. I did a case study on it. It ain't nothing to worry about. All right, what does Lush say? Ain't no way she hired a LIDL lawyer. I don't even know what that means. Y'all know I don't speak Twitch. Y'all got me on Reddit saying I don't speak Twitch. But anyway, look, he throwing shots at Texas, the court, because look, he's super lawyer. Remember, I told you this town is so small. If one person call off, I can't get court documents. An ex parte threat or threat, the Texas Supreme Court concluded that when the marriage is at issue, the burden upon the party seeking support to establish at least a prima facie case marriage. So basically saying, look, you still got to prove just a little bit, even though it's outdated. We know you still got to prove a little bit, whatever. The marriage relationship is, in the absence of statute, a condition precedence to the allowance of alimony, counsel fees, and suit money, pendant like in the actions by the wife for divorce, alimony, and separate maintenance. This is a fancy way of saying, look, she can't get no alimony, no court fees or counsel fees until they are deemed married. It'd be what they call improper. Okay. That's just how I play. Like, it would be improper to award her anything if, like, how you gonna award her spousal support or temporary spousal support, and we don't even know if she's a spouse or not. Like, super lawyer is like, look, what are we doing here, guys? I hope y'all writing this down because we're gonna go through a summary because I wrote it down. So Ex parte 3 predates Section 2.41, which lays out the 3 elements must be present for informal marriage to exist. Thus, the ex parte threat case is grounded in common law and not statute. So basically, common law is just like, it's not really on the books, but it's kind of on the books where it's like statute. If you go down there and you sign the marriage certificate and you have the ceremony, you're married. But common law is like, well, you know, you live together, you held yourself out, then I guess you're married. Smasher. Okay. If the court applies the prima facie standard for this temporary orders hearing, the evidence shall be considered in light of relevant case law discussion here and below. All right, guys. The red part. Look, if you are getting divorced in Texas, if you can afford this guy after Mr. Cow come through, you better hire Mr. What's his name? What's his name? Adam J. Morrison. Adam J. Morris. Put some respect on his name, goddammit. All right. Look at this. This red part, write it down, guys, because this is basically what he's doing is knocking down how you can prove it. In ex parte threat, the Supreme Court held that there was no prima facie case of a marriage because the alleged wife had only told 4 or 5 people of the alleged marriage. She continued to use her own name. The parties never occupied the same residence, and she publicly represented herself as a single person. Okay, so guess what, guys? Why has she ever said she was single? Has she ever said she was single? Look, so now 4 or 5 people ain't enough. You got 5 people you told? What about your 300 subs? Did you tell them you were married? No. We were keeping it private. We were doing what we were.
Certain things have to be kept private.
We were keeping it private. Okay, y'all are keeping it private. All right, cool. Keeping it private. So why you ain't tell your 4 or 300,000 people? We were keeping it private. We didn't want to mess up our fan base. Okay, all right, fine. You don't want to mess up your fan base. Cool. What's your last name? I never got around to change it. Oh, what? Wait, what? You never changed your last name? No, I did not change it. I did not change my last name. Okay, so you only got 4 or 5 people, which is probably immediate family. And you never changed your last name. And you've been telling people you were single. Okay, all right. But you were married to Mr. Cow, right? Yeah. All right, okay. All right, okay. You were married to Mr. Cow. You never changed your last name. You told other people you were single. All right, okay. Hopefully, look, someone said GG. What GG? We're just at the first part. We didn't even get to where we need to go, guys. We did not get to where we need to go. This is part 1. And you know how many parts it is? Like 8. It's like 8 parts. So hopefully you guys writing it down. Y'all ready to dead her right now on part 1. Like I said, I don't have anything against Sammy, but I'm just going by what the super lawyer said. So that's just the Supreme Court. 4 or 5 people ain't enough. You didn't change your last name. You never occupied the same residence. Remember, in Texas, and you publicly represented yourself as single. Okay? Single. So look, super lawyer, that's just part 1. And people are like, GG. What about parts 2 through 8? What about parts 2 through 8? All right, let's get to part number 2, guys, because we only at part number 1. This part number 1, hopefully y'all wrote this down. 4 to 5 people ain't enough. You didn't change your last name, and we have to live together. Remember, everything has to occur in Texas. In its reasoning, the court stated that the isolated references to a person as being his or her husband, wife, constituted no evidence of common law marriage. So now we got the 4 or 5 people. Now look, in Dana v. Dana, this is part 2, guys. This is part 2. Buckle up. In Dana v. Dana, the Dallas Court of Appeals held that there had been no informal marriage because there was not sufficient evidence of the parties holding out to the public as they were husband and wife. Okay, he's like, Dana v. Dana, what do you mean holding out? The court stated that the couple's reputation in the community as being married is a significant factor in determining holding out being married. Okay, all right. What does it say? At the proponent of the informal marriage provided 4 occasions on which she or the alleged husband introduced each other as husband and wife. So if Sammy said, "Hey, this is my husband," and he was like, "This is my wife," on 4 times, they like, look, Dana v. Dana said that ain't enough. Like 4 times, that's it. Y'all married for 2 years. What? You only just do stuff as husband. 4 lawyer. Order in the court. I know y'all probably lose this. This is part 2. All right. She also introduced an AARP enrollment form that showed her as his wife and that he admitted signing it. Okay. So you introduced him as on your AARP and he signed it, but y'all still wasn't husband and wife. This is getting bad. This is getting bad, Sammy. On the lease, did you put husband and wife? Where I need to rock. It doesn't matter. It doesn't matter because Dana v. Dana said, hey, it don't matter. The court concluded that the evidence did not show they consistently conducted themselves as husband and wife in the public eye and that the community viewed them as married. Do y'all are the community. Do you view them as being married? Do you view them as being married? Be honest, guys. All right, you know what? I think y'all want to poll. We'll close it. We'll come back to this one. I think y'all want to poll. 90% said Sammy ain't gonna prove it. So, and that's 3,000 people voted. Let's start a poll. Please be honest, guys. I know you've been watching them for years. Do you view Sammy and Mr. Cow as husband and wife. I think I know how y'all gonna answer, but I just need to confirm. I need to gather some data because Mr. Cow can maybe use this in his case, guys. He may be like, hey, Henry, we're gonna pull up Henry's video. He polled 3,000 people, and we all determined that they were not indeed husband and wife. I know, like her.
How dare you?
How dare you not deem her husband and wife? I don't know, but in Smith v. Devine, all right, the Dallas Court of Appeals affirmed that the trials court direct verdict, there was no informal marriage. Okay, well, why? The proponent of informal marriage stated in his summary judgment affidavit, after Mary accepted my ring, we began to introduce each other as husband and wife and testified when we have been out together, we've been introduced by others as husband and wife. Neither May or I would tell anyone that we were husband and wife. Uh-oh. 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 This is another part. So hold on, let me get through it. The proponent also relied on certain contracts in which he and the appellee were listed as husband and wife. However, the evidence was not sufficient, and the court held that there was no informal marriage because the element of holding out requires more than one occasional reference to each other as husband and wife. Uh-oh, guys. Sammy, this is part 3. So you mean to tell me, let me just get, if Mr. Kyle bought you a ring and y'all introduced yourselves on a couple occasions as husband and wife, and someone introduced you as husband and wife, that didn't count? Like, and you what are we doing, guys? Where is the case? How are you going to prove this beyond a reasonable doubt that you were married? Oh gosh. All right, guys, we cooking. We cook. Who voted yes? I really want the person who voted yes to come out. It's probably Sammy. Like, all right. Who we got? Shout out to Al Cool. Shout out to Lil Bro's offline chat. LMA, Rip Bozo, Adept Easy. Look, guys, I cannot see the Twitch. If I bring up Twitch, we gonna drop stream. So I'm just letting my mods do what they do over there. Hopefully they being respectful to everybody. Hopefully they conducting some polls on the air. Let him cook. Let me cook. I'm not cooking. The super lawyer is on fire. You ever play NBA Jam and you make 3 in a row? You like, uh-oh. He's on fire. He's 3 for 3 from long range. And that's when you get that on fire. But look, he just slowly turning up the heat, just slowly cooking. He's like, oh, I'm a cook. I'm a cook. I'm a professional, goddammit. I've been doing this longer than both of them been alive. How can I lose? I was there when they created the law. No, shout out to the super lawyer. Shout out to the super lawyer. We gonna keep it going, guys. We gonna keep it going. I'll go over it again. Even if you bought the ring, even if you introduce yourself as husband and wife, even if other people introduced you as husband and wife, y'all still not married. That's tough. That is tough to beat. Okay, we got another court case. This is part 4, guys. Uh-oh, I don't want to show the red right away. In Small v. McCaster, the appellate court held that the evidence was factually insufficient to support the judgment of an informal marriage. You're like, but why? Why was it insufficient, guys? Why was it insufficient? The evidence presented included the proponent presenting evidence exclusively from her own witnesses. You mean her mom, her dad, maybe some cousins? That she and the opponent held out to some family and friends and acquaintances that they were married, while the opponent presented evidence through his witnesses that he never held out to the parties as being married. Whoa. Do y'all see this? Do y'all see what's happening? Hey, I don't care if she told her mom and dad we were married. I never told my mom and dad we were married. And so what we doing here, Judge? And you're like, wait. Sammy, did you tell mom and dad y'all were married? Well, yeah, because we are. Mr. Kyle, did you tell your mom and dad you were married? Never, because we were not married. I I never got around to it, but we were never married, guys. Like, come on, like, what are we doing here, guys? Anyway, that's my Mr. Cow impersonation. But the answer is no. It's an unequivocally no. If he didn't tell his millions of fans, why would he tell? Oh gosh, man, it's not looking good. What does the court say? What does the court say? The court reasoned that the occasional introductions as husband and wife are not sufficient to establish the element of holding out. Like, hey, this looks like another win. Is this another win for the super? Look, is he worth his weight in gold? God damn it. Order in the court. Order in the court. Order in the court, goddamn. Hey, the 11% of y'all that said they were married, chill out. I hear y'all getting too loud in the back. And we still got 4 more parts to go, guys. We got 4 more parts to go. We got to get through Super Lawyer's brief, goddamn it. We gonna do it. So let me just read that one more time for you guys. The evidence presented included the proponent presenting evidence exclusively from her own witnesses. Like, I'm sorry, I'm trying to keep composure. That she and the opponent held out to some family, some. Why not all? Well, I didn't think it was important to tell them, and they weren't my close friends. But you said you were married, Sammy. You said you married Mr. Cow. But why would you tell some people? Your Honor, he's yelling at me. He's hurting my feelings. All right, sorry, Sammy. I'm getting a little too animated. But did you tell some family members and some not that you were married? Yes, only some. Okay. All right. And did they present their case that you were married? Yes, they gonna testify that I told them. Okay, cool. But what if I told you don't have to testify? Because we don't care about your witnesses. Because we know they have a financial vested gain in you being married, Sammy. We do. Now look, guys. I like Sammy. I'm just Mr. Cow's attorney. And we just want to, do what's fair, Your Honor. Anyway, so basically, if she held out to some people while the opponent presented evidence through his witnesses. So if he has witnesses, which we are all witnesses, I'm like, yo, I watched about 10 hours of Mr. Cow's videos during the time that they were married. And not one time did he say he was married or interested in marriage or remotely close to being married. And I got about 1 million others who would say the same thing, Your Honor. So anyway, let's go on. I think this is part 5, guys. Is this super lawyer cooking or is he cooked? Is he worth his weight in gold? That's what I want to know. Is he worth his weight in gold? I'm telling you, how can she win? How can she win? How? It's looking impossible. And we still got 3 more to go. We still got 3 more to go, guys. Instead, the couple must have a reputation in the community as being married. This reputation must be proven by evidence that the couple consistently conducted themselves as husband and wife in the public eye, not the private eye, the public eye, or that the community viewed them as married. Additionally, both parties must have presented themselves as married. Uh-oh, we got a problem, guys. Sammy, Sammy, what are we using as evidence? What are we using as evidence? Because super lawyer, like, look, it makes it seem like you better have a ceremony if you want to use any evidence. Like, what are we doing, guys? What are we doing? Anyway, let's keep going. Let the super lawyer do his thing. Uh-oh. Occasional references to my wife or my husband do not prove a tacit agreement to be married without corroboration. And you look at my man. Hey, Flores v. Flores. Hey, what are we doing? Oh my goodness. Specifically, if the statement is made in a self-serving context, it may not have great. Wait. So you mean to tell me if Sammy said, Mr. Cow is my husband, it has no weight according to Flores v. Flores because it's self-serving? Uh-oh. What we gonna do? What is her defense team thinking right now? What is her defense team like? They're probably watching this like, yo, we gotta shut down Henry's stream. He's tainting the witnesses. He's tainting the jurors. He's tainting. We just got a little bit more to go through this, but this is wild. Like, how is she gonna prove it? Specifically, if a statement is made in a self-serving context, it may not have great weight. The non-social context of the contestant's reference to a proponent and his wife's or her husband will receive scrutiny. Look at him, Russell Reed Russell. Like, hey, you said we were married. Russell V. Russell said we don't gotta take your word for nothing. So anyway, I'm sorry, guys. I'm being a little animated. Let's keep going. That was it. That was it